Sir, let me see your ID.
I'm sorry, what?
Identification, now.
I'm having lunch. Is there a problem?
Stand up and step
I
outside
haven't
with
done
me.
anything.
Turn around, let's go.
The body camera footage from ATX Cocina on South Congress Avenue in Austin, Texas, begins at 12:12 p.m. on a Wednesday afternoon in August. Interior of the restaurant, midday lunch rush, roughly 20 tables occupied, soft background noise, plates, conversation, the occasional laugh from a table near the bar. Near the window, there's a black man in his early 50s, wearing a navy blazer over a striped dress shirt, sitting alone at a corner table. He has a plate of grilled salmon in front of him, a fork in his right hand. He's not on his phone, he's not causing a scene. He's eating lunch the same way he's eaten lunch at this restaurant dozens of times before. Normal Wednesday afternoon. Then Officer Jacob Sutherland enters the frame. What Officer Sutherland does not know, or does not care to find out, is that the man with the salmon is Judge Winston Delroy, United States federal judge for the Western District of Texas. He has presided over more than 2,400 federal cases in 13 years on the bench. He has written opinions cited by appellate courts 39 times. He has sentenced corrupt law enforcement officers to federal prison. He understands the Fourth Amendment with a depth that most constitutional law professors would envy. And in approximately 4 minutes, Officer Sutherland is going to detain him in front of a full dining room, walk him out of the restaurant in handcuffs, and trigger a federal lawsuit that will cost the state of Texas $4.2 million, and force Austin PD to implement reforms that no department in this state has ever been compelled to accept. Winston Delroy is 54 years old. He has been making prosecutors nervous from the bench since he was appointed to the federal judiciary at 41. He was raised in Houston's 3rd Ward, the son of a postal worker and a high school English teacher. Two people who understood, with the clarity that comes from experience, that their son's path would need to be flawless, where others only needed to be adequate. He graduated valedictorian from his high school class, full academic scholarship to the University of Texas at Austin, law review at UT Law School, 8 years as a federal prosecutor in the Southern District of Texas, with a conviction rate that drew the attention of the Judicial Nominations Committee, private practice, state district court, then the federal bench at 41, a lifetime appointment, one of the most consequential jobs in the American legal system. 13 years presiding over drug trafficking conspiracies, public corruption trials, civil rights violations, and police misconduct cases. Defense attorneys over-prepare for his courtroom because he reads every exhibit, catches every inconsistency, and writes opinions that are nearly impossible to overturn on appeal. He has granted injunctions against police departments. He has upheld them. He has ruled on the constitutional limits of stop and frisk, search and seizure, and qualified immunity, not as an academic exercise, but as binding law. He is also black, which most days does not matter inside his courtroom, where the robe and 30 years of legal authority command the room without question. But outside the courthouse, in restaurants and parking lots and on sidewalks, the robe doesn't travel with him. Out there, people look at Winston Delroy and make calculations that have nothing to do with who he actually is. That Wednesday afternoon, Winston is doing what he does every Wednesday, lunch at ATX Cocina, 4 blocks from the federal courthouse on Lavaca Street. He's been coming here since his first year on the bench. The staff knows his name. His usual server knows his order. He has eaten at the same corner table enough times that it has, informally, become his. He arrives at 12:09 p.m., grilled salmon, side salad, sparkling water with lime. He opens a brief on his phone, reads for 90 seconds, then sets it face down on the table. Orders. Waits. The food arrives quickly. He picks up his fork. 3 blocks away, Officer Jacob Sutherland receives a dispatch call. Report of a suspicious male at ATX Cocina on South Congress. Caller states subject is acting aggressively near the dining area. No weapon reported. Requesting police presence. Sutherland, 6 years with Austin PD, 2 prior complaints on record, both involving black men, acknowledges the call. He does not ask what behavior specifically is aggressive. He does not ask whether the caller has direct knowledge or second-hand concern. He simply confirms he is 2 minutes away and heads toward the restaurant. He arrives at 12:11 p.m. He enters ATX Cocina. Scans the room. Full lunch crowd, predominantly white clientele. His eyes move across the dining room and stop at the corner table, where a black man in a blazer is eating alone. Sutherland's mind, primed by the word suspicious, makes a connection that has nothing to do with observed behavior and everything to do with something else entirely. He crosses the room. Winston looks up from his plate, only when the shadow falls across his table. "Sir, I'm going to need to see some identification." Winston sets down his fork, measured, calm. The kind of calm that comes from having cross-examined hostile witnesses for 2 decades. "Identification? I'm having lunch. What is this regarding?" "We received a report of suspicious activity in this establishment. I need your ID, and I need to know what you're doing here." Winston feels the familiar weight of it, the demand to account for his presence in a room he has every right to occupy. He has felt it before, not in his courtroom, not at the bench, but out here, in the world outside the robe. It comes for him the same way it comes for everyone else. "Suspicious activity," he says carefully. "I am sitting at a table in a restaurant where I have a reservation and a history as a regular customer. What specific behavior have I engaged in that constitutes suspicion?" Sutherland's voice flattens. "Sir, I'm not going to repeat myself. Show me your ID or I will detain you." Around them, conversations are stopping. A server near the bar has gone still. 2 women at the next table are watching. Someone near the window already has their phone out. Winston calculates, the way he has always had to calculate in spaces like this. He can produce his credentials and likely be dismissed in 30 seconds. Or he can do what 13 years on the federal bench have trained him to do. Demand legal justification. Document what is happening. Force this officer to say out loud what he actually has. He is a federal judge. He knows the law precisely. He knows this stop has no legal foundation. And he is tired. The bone-deep, career-long kind of tired of being required to prove he belongs in rooms where his belonging was never supposed to be in question. "On what grounds?" Winston says, his voice low and even. "What articulable, reasonable suspicion do you have that I have committed or am about to commit a crime? Because if you cannot answer that question, officer, you do not have the legal authority to demand my identification." Sutherland's hand moves toward his belt. "You're being uncooperative." And the body camera keeps rolling. The dispatch came in at 12:09 p.m. Suspicious male, dark suit, acting erratic. ATX Cocina, South Congress Avenue. No altercation, no victim, no weapon described. Just a call from someone who had seen something that made them uncomfortable, which, in Austin in 2026, was still enough to send a badge through the door. Officer Jacob Sutherland had been with APD for 6 years. He had 2 prior complaints on his record. Both involved black men. Both had been dismissed. He walked into ATX Cocina at 12:11, let the door close behind him, and scanned the room the way officers are trained to, systematically, neutrally, building a picture. Except the picture Sutherland built took less than 4 seconds. Full dining room, mostly white lunch crowd. 1 black man sitting alone at a corner table in a dark blazer, fork midway to his mouth. He didn't pause to observe. He didn't watch for erratic behavior. He walked directly to the table, hand drifting toward his belt before he'd spoken a single word. "Sir, I need to see your ID." Winston looked up slowly, set down his fork. "I am a United States federal judge. My name is Winston Delroy. What is the basis for this contact?" Sutherland didn't answer the question. He restated the demand. 90 seconds later, Winston was on his feet, hands pulled behind his back. A busboy at the service station dropped a glass. A woman near the window raised her phone. Winston closed his eyes, exhaled once, slowly, quietly, like a man absorbing something he had always known was coming and had simply been waiting, all these years, to arrive. He was released 22 minutes later. No charges, no formal explanation. A supervising sergeant arrived, spoke briefly with Sutherland in a lowered voice, then turned to Winston with the carefully neutral expression of an institution trying to contain damage it already knew it had caused. There had been a miscommunication, the sergeant said. They appreciated his patience. Winston said nothing. He straightened his blazer, picked up his phone from the table where it had been set during the detention, and walked out of ATX Cocina into the afternoon heat. The salmon was still on the table. He hadn't finished it. He drove back to the federal courthouse on Navaca Street alone, took the elevator to the 4th floor. His clerk looked up when he came through the door and started to say something. Winston shook his head once, quietly, and kept walking. He sat in his chambers for a long time without turning on the lights. That evening, he called Priya Nair. She was one of the most respected civil rights litigators in Texas. 3 landmark police accountability verdicts, 2 of them resulting in departmental consent decrees. She had been on the other side of courtrooms Winston had presided over. She knew how he thought. More importantly, she knew what the footage was worth. Her response to his account lasted about 45 seconds. Then, "We file Monday." Winston was quiet for a moment. He had spent 13 years as the steady hand in the room, the one who absorbed chaos and returned order, who weighed every argument without becoming one. Going public meant surrendering that. It meant every future ruling scrutinized for grievance, every decision filtered through the story of a man in handcuffs at a lunch table. It meant being seen, plainly and permanently, as a man before he was a judge. "If I do this," he said, "I become the story." Priya didn't hesitate. "Winston, you already are." He authorized the filing before he went to bed. The 68-page federal complaint was filed at 9:14 a.m. on a Monday morning in the Western District of Texas. By noon, it had been picked up by the Austin Chronicle. By 3 p.m., a local television station had obtained a portion of the Bodycam footage through a public records request that someone, somewhere inside APD, had apparently decided not to slow walk. By Tuesday afternoon, the clip was everywhere. 41 seconds. That's all it was. A fisheye lens, a timestamp, a well-dressed black man being walked in handcuffs through the dining room of a restaurant, while other patrons watched in silence, and a plate of uneaten salmon sat cooling on the corner table behind him. 41 seconds that had been recorded, filed, and almost buried, until they weren't. The internet did the rest. The clip hit Twitter first, then TikTok, where it was stitched and reacted to and dissected by legal commentators, civil rights activists, retired officers, and ordinary people who had their own versions of this story and recognized it immediately. By Wednesday morning, it had been viewed 11 million times. The hashtag Judge Delroy trended nationally for 4 consecutive days. Cable news ran the footage on a loop, bracketed by panels of legal analysts explaining, with increasing urgency, exactly how many laws Officer Sutherland had appeared to break in under 2 minutes. The city of Austin issued a statement by Wednesday afternoon. They took all such incidents seriously. A full internal review was underway. The department remained committed to constitutional policing and community trust. The statement satisfied no one. By Thursday, the city's legal team had reached out to Priya Nair through back channels. They were prepared, they suggested, to discuss an early resolution. They floated a number, $800,000. A quiet settlement, no admission of wrongdoing, a mutual agreement to move forward. Priya relayed the offer to Winston. He read it once and set it down. She conveyed his non-response to the city. The following Monday, they came back with $2.1 million, structured as a confidential agreement with a broad non-disparagement clause that would have prevented Winston from discussing the case publicly. Ever. Priya typed her reply herself. 2 words. See you in court. 3 weeks after the complaint was filed, Priya's team sent subpoenas to Austin PD for 5 years of stop and ID data across Travis County. The department's legal office objected, delayed, and then, under court order, complied. What came back was not a surprise to anyone who had been paying attention, but it was the kind of documented, time-stamped, departmentally generated evidence that transforms an argument into a case. 83,000 pedestrian stops over 4 years, 83,000 instances of Austin police officers approaching civilians and demanding they identify themselves. Not during traffic stops, not following arrests, just stops, people on sidewalks, in parking lots, outside restaurants, going about their lives, who were required to account for their presence to a badge. Black residents of Austin made up roughly 8% of the city's population. They accounted for 58% of those stops. No combination of crime rate differentials, patrol concentration data, or deployment patterns could explain a gap that wide. Priya's expert witness, a criminologist from the University of Texas who had testified in 4 prior police accountability trials, ran the models 6 different ways. The disparity held every time. Then there was Sutherland specifically. In 18 months, Officer Jacob Sutherland had initiated 41 pedestrian ID stops. 37 of the individuals he stopped were black or Latino. Priya's team mapped each stop by location, time of day, and stated justification. 14 of them listed the same rationale in the incident report. Subject appeared out of place. There was also the 2024 complaint filed by a black man named Terrence Gould, who reported that Sutherland had stopped him in a parking garage outside a downtown hotel and told him, directly, that he looked like he didn't belong there. The complaint had been reviewed by APD's Internal Affairs Division. It had been dismissed in 11 days. No disciplinary action. No notation in Sutherland's personnel file. Nothing. Priya read the dismissal memo twice. Then she added it to the exhibit list. This was no longer a case about one officer and one bad afternoon at a restaurant on South Congress. The data had made that impossible to argue. What happened to Winston Delroy on that Wednesday was not an aberration. It was a pattern with a paper trail, and now the paper trail belonged to her. The deposition of Officer Jacob Sutherland took place on a Thursday morning in a conference room on the 14th floor of a downtown Austin office building. It lasted 6 hours. Sutherland arrived with 2 department attorneys and left, by all accounts, looking considerably smaller than when he'd walked in. Priya started at the beginning, not with the detention, with the dispatch call. She asked Sutherland to describe, in his own words, what information he had received before entering ATX Cocina. He recited the basics. Suspicious male, dark suit, acting erratic. She asked him what erratic meant, specifically, in the context of a dispatched call. He said it was the word the dispatcher used. She asked whether he had requested any clarification about what behavior had been observed. He said no. She asked why not. He said he used his judgment. Then she walked him through every second of the body cam footage, pausing at intervals to ask the same question in different forms. What, at this precise moment, was the specific articulable fact that gave him reasonable suspicion to believe Winston Delroy had committed, was committing, or was about to commit a criminal offense? Terry versus Ohio requires an answer to that question. The Fourth Amendment requires an answer to that question. 6 years on the force and a law enforcement training certificate require an answer to that question. Sutherland could not provide one. Not at the moment he entered the restaurant. Not at the moment he crossed the dining room. Not at the moment he opened his mouth and demanded identification from a man eating lunch. He had a dispatch call. He had a description, dark suit, erratic, that matched nothing he had actually observed. And he had, sitting alone at a corner table, a black man in a room full of white ones. That was it. That was all of it. 2 weeks later, Priya deposed the woman who had made the call. Sandra Pelham was 58, a real estate agent who lived in the Barton Hills neighborhood and lunched at ATX Cocina occasionally. A review of her call history with APD dispatch revealed 7 similar reports over the previous 3 years, all of them describing black or Latino men in upscale restaurants, hotels, or shopping areas. None of the calls had resulted in arrests. None had involved any confirmed criminal activity whatsoever. Under oath, Priya asked her what, specifically, Winston Delroy had been doing that she considered aggressive. Sandra Pelham paused for a long moment. He just looked out of place. Priya didn't raise her voice. She didn't need to. Out of place, she repeated. At a restaurant. In America. Eating lunch. The court reporter typed it into the record. The room was very quiet. The mediation session was scheduled for 2 days. The city arrived prepared to end it in 1. They sent 4 attorneys, 2 department chiefs, and a communications director. 7 people arranged on one side of a long conference table on the 9th floor of a building 3 blocks from the courthouse where Winston Delroy had spent the last 13 years of his life. The configuration was deliberate. It was designed to signal seriousness, institutional weight, a city that took this matter gravely and was prepared to resolve it responsibly. Winston sat across from all of them in a dark suit. No robe, no gavel, no title on the door behind him. Just a man with 27 years of legal experience and a very clear understanding of what the evidence showed. The city opened at $3 million. Attached to the offer was a proposal for mandatory sensitivity training across APD's patrol division and a written commitment to review stop and ID policies within 18 months. Their lead attorney presented it with the measured confidence of someone who considered the number generous and the policy language sufficient. Priya let him finish. Then she slid a single document across the table. The counter-proposal was detailed and specific. Mandatory body cam activation the moment an officer exits their vehicle on a call, with footage housed in a civilian-accessible archive. A civilian oversight board with genuine subpoena power, not an advisory panel with no authority. A racial disparity trigger. If black residents were being stopped at more than 1.5 times their share of the population, an automatic audit would commence. Personal liability insurance requirements for officers carrying repeat misconduct complaints. And the immediate termination of Officer Jacob Sutherland. The city's lead attorney read through it. Then he looked across the table. "You know, we can't agree to all of that." 2 hours had passed since Winston had said a single word. He looked across the table with the same expression he used when an attorney had just made an argument the evidence didn't support. "Then we'll let a jury decide." By the morning of day 2, the city had moved considerably. Sutherland's termination, accepted. The Civilian Oversight Board, accepted, with minor structural modifications Priya had reviewed and approved. Bodycam protocols, personal liability insurance, the civilian footage archive, all accepted, with implementation timelines attached. One item remained, the racial disparity trigger. The city's lead attorney had come back overnight with a counter. They would accept a trigger, but at a 2-to-1 threshold rather than 1.5-to-1. It was, he explained, the recognized industry standard in comparable consent decrees across the country. It was defensible, it was precedented, and it was, in the city's assessment, operationally workable in a way that 1.5-to-1 simply was not. Winston listened to the full argument without interrupting. Then he opened the folder in front of him, the city's own crime and demographics data, the same data Priya's expert had used, the same data APD had generated and filed and apparently hoped no one would read. This carefully. He walked them through the arithmetic without theatre or impatience. Austin's black population was 8% of the city. A 2-to-1 trigger meant that black residents could be stopped at 16% of the total stop rate, twice their population share, before a single audit was required. Given the volume of stops the department conducted annually, that threshold permitted thousands of potentially unjustified stops before any mechanism of accountability was activated. He closed the folder. 1.5-to-1, he said. That is the line. That is not a negotiating point. The room went quiet, in the specific way rooms go quiet, when everyone present understands that the person who just spoke will not be moving. The city's attorneys requested a recess. They were gone for 40 minutes. When they returned, the lead attorney sat down, uncapped his pen, and initialed the page. The settlement was finalized on a Friday afternoon and announced the following Monday. The number was $4.2 million, but the lawyers who read the full agreement understood immediately that the money was not the story. The terms were unlike anything a Texas court had previously compelled a law enforcement agency to accept. Mandatory body cam activation from the moment an officer exits their vehicle on a call, not upon contact, not upon escalation, but from the first step. A civilian police oversight board with binding review authority and genuine subpoena power, not the advisory capacity the city had initially proposed. The 1.5-to-1 racial disparity audit trigger, the first of its kind in Texas history, written into enforceable consent language, with annual reporting requirements and independent verification. Officer Jacob Sutherland was terminated and formally barred from law enforcement employment anywhere in Travis County. And in a provision that legal scholars would cite for years, Sandra Pelham was identified by name in the public record as having made a pattern of racially biased emergency calls, the first such finding entered into a civil proceeding in the state of Texas. Priya Nair, asked by a reporter whether the settlement represented a victory, paused before answering. "It's a floor," she said, "not a ceiling." Winston held a press conference on the courthouse steps on a Tuesday morning. He stood at the podium for a long moment before he spoke, long enough that the cameras shifted and the crowd went still. "I didn't do this because I'm a judge," he said. "I did this because I'm a black man. and every black man in this city deserved this outcome long before I walked into that restaurant. Nobody who was there forgot the silence that followed. The Year 1 compliance report was released on a Thursday morning by the newly established Austin Civilian Oversight Board. It was 31 pages long, written in the dry, precise language of institutional accountability, and it contained numbers that no one on either side of the mediation table had been certain would materialize. Pedestrian stops of black residents in Austin were down 23% from the prior year. The racial disparity trigger had been activated once, a cluster of stops in the East Austin Patrol District that upon audit revealed a pattern concentrated in 2 officers. Both were terminated within 90 days. Over 400 civilians had submitted bodycam footage requests in the first 12 months of the new archive system. 94% of those requests had been fulfilled within the required window. The system was not fixed, but it had moved. A few weeks after the report was released, Winston returned to ATX Cocina for the first time since the settlement. Same corner table, same grilled salmon. He sat alone for a while, eating without checking his phone, the way he used to before any of this had happened. A young man approached him hesitantly from across the dining room, mid-20s, backpack over one shoulder, the careful posture of someone who wasn't sure of his welcome. "Judge Delroy? Last month an officer tried to stop me outside my apartment. I knew my rights. Because of the new logging rules, he had to document the stop. His supervisor reviewed it. The officer received a formal warning." Winston looked at him for a moment. Then he gestured to the empty seat across the table. "Sit down," he said. "Tell me about yourself." The footage, the salmon, the handcuffs, the line that had finally held. None of it was ever just about one lunch.